Good evening. Welcome to Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathis, and I'll be your host tonight. Our topic tonight is negligence and the law. I have three fine guests to help us with tonight's topic. My first guest is the Honorable Tom V. Lyons. He's a judge in the Circuit Court of Cook County. He was appointed judge by the Illinois Supreme Court in August of 2008. Presently, Judge Lyons is assigned to the 1st Municipal District Civil Jury Call. Judge Lyons graduated from Northwestern University and got his JD from the Loyola University School of Law in 1986. He's presented numerous continuing legal education programs and was the Midwest Law Enforcement Executive Development Seminar instructor in 2000. He is a member of the Chicago Bar Association, the Illinois Bar Association, the Women's Bar Association of Illinois, as well as the Catholic Lawyers Guild. Judge Lyons was honored by the Cook County State's Attorney for outstanding contributions to the citizens of Cook County through exceptional dedication and commitment, superior leadership, and remarkable work ethic in November of 2005. Judge Lyons, welcome to the show.
Thank you, sir.
My second guest is Karen Enright. She is the founding partner of Winters Enright Salzetta O'Brien LLC. Ms. Enright focuses on catastrophic personal injury and medical malpractice cases. She currently is on the Board of Governors for the Illinois State Bar Association and has recently been elected Treasurer of the Illinois State Bar Association. She is the past president of the Women's Bar Association of Illinois. She has tried and settled multiple cases and has achieved multiple million-dollar verdicts in areas of personal injury and medical malpractice. Recently, she was rated by Chicago Magazine as one of the top 50 women lawyers in the state of Illinois and top 100 lawyers in the state. She has also been recognized as a super lawyer and has received various awards for public and community service. Karen, welcome to tonight's show.
Thank you, Sam.
And my final guest is Ron Kalish. Ron has been a trial lawyer since 1992. He is a partner with the firm of Steinberg, Goodman, and Kalish, where he concentrates his practice on personal injury, medical malpractice, and product liability. Mr. Kalish has tried numerous cases to verdict in the areas of medical negligence, nursing home neglect, motor vehicle crashes, premises liability, and cases against municipalities and common carriers. He's argued cases before the Illinois Appellate Court, the Court of Claims, and is admitted to the practice before the United States Supreme Court. In his spare time, Ron has volunteered and teaches constitutional law to 7th and 8th graders in the Chicago public school system through a program called Lawyers in the Classroom, coordinated by the Constitutional Right Foundation. Ron, welcome to tonight's program.
Thanks for having me.
You know, you hear the word negligence. Why don't you tell the audience what is negligence and what is a negligence case?
Well, negligence is when someone's conduct is measured against what a reasonably careful person would do under those circumstances. And that really isn't defined, and it's something that's decided ultimately by a jury, whether a person's conduct was reasonably careful or not. And that's what negligence is.
And how do you prove something like that?
I think one of the easiest examples would be probably in an automobile case, where you have two people that are driving, and say there's a stop sign, one person has a stop sign and the other person doesn't. So the person who doesn't have the stop sign usually has the right of way. If the person blows through the stop sign or is speeding and hits the other person, one of the questions is, were they acting as a reasonable driver would under those circumstances? If they blew the stop sign or if they were speeding, they wouldn't. And that is proved through the testimony of the people that were driving the car, or through a police officer who might have come to a scene, or an independent witness. And
who decides whether a person is negligent or not?
Sam, the jury instruction at the close of every trial I'm conducting, we always instruct as you're aware, instruct the jury, and there is a jury instruction on negligence, and specifically it says what a reasonably careful person would do under circumstances is not defined by the law. It's up to you, the jury or the trier of fact, to decide.
And when we say the jury, who is the jury? Who's the jury made up of?
The jury is made up of, depending upon the case, in most cases 12 individuals. In some cases, in small claims cases, it can be 6. But it's a jury of peers chosen by the lawyers. And when I'm doing jury selection, I'll begin with some preliminary questions, and then I turn it over and I allow the attorneys in the case to ask questions of the jurors.
And I'm sure a lot of people who are watching the show wonder about jury duty, may have served on jury duty. Those who haven't, what is jury duty, and how did somebody come about being a juror?
Well, the pool of jurors are selected off, and I don't know if I should say this because people may decide not to cancel their voter registration, but in Cook County they use the voter registration, and people will get a summons where you fill out the questions on the back and then you come down. And then depending upon the needs of the court that particular day, you may be called. In Cook County, the system they have is 1 day or 1 trial. So if you're not selected by the end of the day to serve on a case, you don't have to come back. If you do go to a courtroom, you'll be questioned in most cases initially by the judge, and then it'll be turned over to the attorneys for follow-up questions, so that the juries the attorneys and the parties get a fair and impartial jury who doesn't know any of the parties, who doesn't have any preconceived notions. That's what the attorneys are looking for.
But anyone can be a juror. No one is immune. So just because you're a lawyer or a doctor or even a judge, they all have to sit, every one of us has to sit on jury duty. I've been on 2 juries myself, and I'll tell you, I mean, it's been some of the best experiences. It's not just because I'm in the field, but it's just an amazing experience, and I think even Judge Lyons would tell you that 95% of the jurors that go through will tell you it was one of the best experiences they have had, being able to decide important facts on another person's life.
Is a juror paid for their time service?
They get $17.20 a day.
So that probably pays for their transportation down.
If they're lucky, depending upon where they park, and depending upon, and I think in some of the suburban courthouses, I know there was a movement afoot to start charging the jurors for parking. I believe that has been reconsidered, and they're not going to do that.
And if you are not selected, then you're done for your jury service for a time period, correct?
Right.
And if you are selected, how long typically do you have to serve on the jury? What is the average case time? Is there anything particular?
It depends on the case. The cases that I'm hearing in First Municipal, my trials generally last, I'll start picking early in the morning. Most cases I'm done with in that day, sometimes 2 days. But
so typically in a lot of the municipal cases, if you're a juror selected, you're a day or 2 and you're done with the service, correct?
Correct.
In every case is different. In larger cases that last longer, it can be days, it can be weeks sometimes.
Getting back to these negligence cases, what if there's can more than one person be negligent and cause accidents?
Yes. The way the law is in Illinois is if you are a cause of someone's injury, you can be responsible. Now there's some exceptions to that rule depending on how much of a cause you are. And really in the end, the jury decides like a pie chart of percentages, and it even includes the plaintiff, the person who's bringing the lawsuit. The plaintiff can be held partially responsible for their injuries.
And what if the plaintiff is held responsible? What happens in that situation?
If the plaintiff is held more than 50% responsible for their own injury, they lose. They get nothing. And that is part of the jury instruction, something that Judge Lyons was referring to. At the end of every case, the jury is instructed, and if there is more than one defendant or a plaintiff that might be considered contributory negligent for their own injury, that's something that the jury must decide. But if the plaintiff is found at fault 50% or more, they lose.
And what if they're less than 50%?
Well, in most cases where the plaintiff is alleged to have some degree of negligence as well, there'll be 3 different verdict forms. One would be the verdict form where you're finding in favor of the plaintiff, and the plaintiff is not contributory negligent or didn't add to his own injury. His negligence was not a proximate cause of the injury. The second verdict form would be the one where you would reduce it by the percentage of the plaintiff's contributory negligence.
And what does that mean when you reduce it? For instance, if you take a case and a person gets $50,000, how is it reduced?
If the jury would first decide the amount of damages suffered by the plaintiff comes to $50,000 in the example you used, and then the jury would there's another blank for them to fill in the amount of negligence that was approximately the amount of the injury that's approximately caused by the plaintiff's injury was, for instance, 25%. Then they would take that $50,000, subtract 25% of that, assuming that the $50,000 represents 100% of all injuries, and that would give you the final number of the verdict. As Karen said, if the jury found that the plaintiff was 55%, the plaintiff gets nothing. So verdict form C would be if the negligence was greater than 50%, the plaintiff's, or if they just ruled in favor of the defendant, period.
And what is it that you can recover for in a negligence case? What can a person recover for?
In a negligence case, there's several elements. The most obvious ones are you can get your medical bills paid, reimbursed. That's one. If you miss time from work, that's called lost wages or lost earnings. If you suffered pain and suffering, the jury will decide that amount of pain and suffering. You can have a recovery for future medical expenses if you need future medical care. And if there is disability or loss of normal life, and that really means that you are unable to do something that you used to do as a result. Those are the categories. There are some others, but those are the basic categories that you can recover for.
Or if you have some type of disfigurement, some type of scarring, some type of amputation that you would require to have some assistance, something that affects your physical being, you could also recover under that category as well.
Now, if you are injured in a negligence case, who pays for your medical bills while this is all going on?
Well, if you have insurance, usually your own insurance company pays. Oftentimes it's up to you to pay your bills and to front your bills and to cover your bills until the time that you have settled with the defendant, and then their insurance would reimburse for those bills. Most of the time the defendant's insurance does not pay for your bills, and a lot of times people get in accidents and say, well, I don't want my insurance to be charged. Well, then that bill just goes unpaid because the defendant will not necessarily pay for your bills until they've made a determination of liability. So I always recommend to my clients, if you're in an accident and you go to the emergency room, have your insurance company pay those bills. That's what it's there for.
If your insurance company, your health insurance company does pay those bills, what happens at the end of the case with that?
At the end of the case, if your health insurance company has paid your bills, you can't have a double recovery. So if you recovered money in your lawsuit for $25,000 worth of medical expenses and your health insurance company paid those bills or a percentage of those bills, you have to reimburse out of your settlement or verdict. You have to reimburse your health insurance company, and there's a formula for it. It's not quite 100% going back, but it's reduced a little bit. So.
And how about if the bills, like you said, haven't been paid? What happens in that case at the end of the case? Do you have to pay those bills, or what do you do with that situation?
A lot of times those institutions will file a lien. So say you went to a hospital and that hospital bill wasn't paid. The hospital bill will contact your lawyer and they will file a lien, and although they might not want 100% of the charges repaid, they would want a certain percentage of those charges paid. And often they don't ask for interest, but sometimes they do. But in any event, as Ron said, you can't have a double recovery.
Okay, so people hear that, people are getting all this money and everything like that. The bills are eventually paid out of the settlement money. We're going to take a break for a second. We'll be right back. This is Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathis, and we're talking about negligence in the law, and we'll be back in just a minute with my guests.
Bye, Tyler.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association. Over and over. Time and again.
Drive me nuts. Shut up. You're the dumbest.
Generation after generation.
I hate you. I hate you too.
Isn't it time we stop the cycle? Now.
I hate you. I hate you.
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathis, and our topic tonight is negligence and the law. And my guests tonight are the Honorable Judge Lyons, Karen Enright, and Ron Kalish. And we were discussing negligence, and we were talking about the various bills and how they're paid. And what happens in a case where somebody isn't working, they have no money, they've got these bills, and they need money? What can they do? You see these advertisements for a lot of these companies on TV for, you know, if you've settled a case or you've got a settlement coming in a lawsuit and they want to give money out. What about that?
There are companies here in Illinois and in Chicago that will advance or give you a loan and expect to get paid back out of the proceeds of your settlement that hasn't even happened yet. And, you know, those are loans that really are very, very expensive for the client, and it really makes it difficult at the end of a case, because now the plaintiff who has may or may not have the same mindset when it comes to settling a case. They now owe, you know, X amount of dollars, and it makes handling that case very difficult.
How long typically does the negligence case take from the time you filed suit until the time it's completed?
Typically in Cook County it's 2 to 3 years, depending on the complexity of the case. There are different types of cases, from medical cases to construction cases to automobile cases, so it depends on whether or not the case is in the law division, how many parties are involved, how much discovery needs to be done. But sometimes you can wrap up a case in 2 years, and sometimes it takes 5 years, depending on, you know, all the factors that are involved.
Are there alternatives to try and get a case resolved before you have to go to a trial?
I think most attorneys, and most good cases, they like to settle them. If the liability is clear, there's damages, there's proximate cause, it's advantageous to everybody to keep the expenses under control if there's liability. But in any case, the lawyer's going to have to do some work to find out exactly what the case is worth and if they can prove the case.
And how do you settle these cases? What methods are used to settle cases?
Oftentimes we talk to different mediators. There's mediation systems, but also in most courthouses there are judges like Judge Lyons who would take a pre-trial, and sometimes the case is filed and other times the case is not filed. On cases that are not filed, you try to work out something with an adjuster or the insurance company or the defendant. In cases that are filed, oftentimes there are attorneys on the other side that will agree to a pre-trial or a certain type of mediation.
In a mediation, what Karen's talking about is many times there are retired judges, just like Judge Lyons is a sitting judge, but who have sat in courtrooms, presided over cases just like the cases that many of us have. And these are retired judges that will have you come into a conference room, a very informal setting, and gives each side a chance to informally tell their story. And a retired judge is usually very helpful in helping both sides come together on a settlement.
And if you can't settle a case, who decides how much you get in a negligence case?
Ultimately the jury, and those are a jury of your peers, as they say. There are 12 people who know at the start of the case, know nothing about your case, and sit and listen, and they are judging the facts of the case, who's going to win and who's not, and judging the nature and extent of your injury.
So is there any certainty on when you go to trial and you go to a jury trial as to how much you're going to get, or how much, you know, a jury should give in certain kind of cases? Is there anything like that?
There's absolutely no certainty, and I tell my clients that all the time. I mean, a lot of times you feel that you should win and that your client has been injured, and you feel that liability is clear, but you are putting your case and your damages in the hands of 12 people that you don't know. It's the best system that we have, and I don't think any of us would be working in the system if we didn't feel that it was the best system. But there is no certainty. All you can do is hope that you've picked the right people, and you hope that people are honest in jury selection and they tell you whether or not they can be fair and impartial, and if they are the right people for the case. Because we're relying a lot on what they say during jury selection.
Judge, when you've tried cases, or sometimes are the people surprised as to what the verdicts are compared to what you've talked about as far as settlement before the case?
Well, I think, as Karen said, there's no guarantees. I'm surprised sometimes with the outcomes of cases, and sometimes I've also heard of cases that I haven't personally been involved in where the jury has made a decision and they may have come up with a number that may be appropriate, but the rationale or the way they divided up the damages may have come as a surprise.
So if a person gets a good settlement or settlements out there that's reasonable, sometimes from everybody's standpoint, it sounds like maybe it's best to take a settlement because you never know for sure in a jury trial.
I think it's very much to the injured party's advantage to accept a reasonable settlement if it's a fair, reasonable settlement for the injuries, because you never know what the jury's going to do. And also, if things get the expense of trying a case goes up dramatically, particularly in the more serious cases where you have experts involved, because the lawyers have to front the expenses for the experts who are representing the individuals, and it's also more expensive for the defense to try it.
And when you go to trial, the verdict has to be unanimous here in Illinois. And there are occasions, not often, and it's happened to me, where we have what's called a hung jury, where the case is tried, you spend days or weeks trying the case, and at the end, the jurors can't agree on a verdict. And ultimately what it means is you have to do it all over again with a whole new set of jurors.
If you do get a verdict, then do they have to pay you right away?
They have an opportunity. They have 30 days in which they can file an appeal, and either side can do that. So if you're the plaintiff and you lose and you feel that something went wrong during the trial, you have the opportunity to appeal. If you're the defendant and you feel that the verdict is too high or that you were unjustly damages were unjustly assessed against you, you have the opportunity to appeal. So you have a certain period of time in which you can do that, and then it goes up to the appellate court and they make a decision. It's a very long process.
Now, if you do get a verdict, who pays the attorney's fees and who pays all these costs for going to trial, as you said?
Most negligence cases, the kind we're talking about here tonight, there is an agreement that you reach with your lawyer. It's called a contingency agreement, and really what that means is that if you recover money in your case, the lawyer gets a percentage, typically a third, sometimes more if it goes to trial, but typically a third, plus any expenses that the lawyer has put out for the case, the filing of the lawsuit, the serving of the complaint with the sheriff, the taking of depositions, the paying of experts. All that comes back on top of the third fee.
So the client doesn't pay for it ultimately, but they are ultimately going to pay for it at the end in the trial. So that, as we talked about settling a case, you got to figure in all these costs of litigation are involved too, don't you?
It is a client's expense, except if you lose the case as the plaintiff, you don't owe attorney's fees.
Now, as far as picking an attorney, how do you pick an attorney who handles negligence cases? And if you do pick your attorney, what does the attorney need to be, how often you said it takes a couple of years, does the attorney need to be talking to you? What happens typically in a case with the attorney?
You want to pick an attorney who is experienced in the area of medical case or in the area of negligence cases. So if it's a trucking case or an automobile case or a construction case involving a scaffold, or if it's a products liability case involving some type of engineering defect, you want to make sure you have an attorney who is experienced in those different areas. Some lawyers specialize in personal injury like we do, and there are some people who are general practitioners. So you really have to investigate who you are going to see and who's going to represent you, because you want to have the best representation possible.
I mean, a lot of people anybody can advertise, right?
Yeah, so I think the best piece of advice I can give is when you talk to that lawyer, ask them if they've tried cases, ask them if they have taken these cases to a verdict, and you'll be surprised.
Now, during the course of this litigation, if your lawyer isn't talking to you, people say, I haven't heard from my lawyer, I don't know what's going on. I mean, you sign a contract with a lawyer. Do you have to keep your lawyer? You always have to keep your lawyer, or what can you do if you're not happy with your lawyer?
Well, there is a duty for your lawyer to keep you informed about the different stages of your case. If you are not happy with your lawyer, you always have the right to discharge your lawyer, but you need to look at the contract that you signed, because sometimes there is a clause in that contract saying that you might owe your attorney for fees and expenses if you discharge. So you want to make sure that you look at the contract before you take those steps. But If you're not happy with your lawyer, I would advise to sit down with your lawyer and have a conversation that you need to have more communication, or you need to have status letters or something to update you more frequently on your case.
So what do you do to keep your clients advised what's going on? Because you said it's a couple-year process. I mean, I assume you're not calling them every day.
Right, and what Karen hit on, I think, is really important. It's not so easy to just discharge your lawyer and get another lawyer. It's a little bit more complicated than that. Make an appointment with your lawyer. Go into his or her office. Phone calls can get lost, messages can get lost, and it's important to, you know, if the lawyer can't give you that information, ask his or her assistant, and sometimes they can tell you what's going on with the case.
And sometimes if you ultimately do decide to discharge the lawyer, it may really delay things. The case may be close to trial. Now a new lawyer comes in, the initial attorney is withdrawing, a new attorney files an appearance, says, Judge, I'm not ready. I need time to get up to speed. Well, this case is set for trial. And you may have some difficulty with the judge in that regard.
All right, well, listen, thanks a lot. We're just run out of time. I'd like to thank my guests, Judge Lyons, Karen Enright, Ron Kalish, for being our guests tonight on Illinois Law, sponsored by the Illinois State Bar Association. And my name's Sam Kavathis. I'm your host tonight, and thank you for watching.